Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about magazine bans again because it is really heating up at the United States Supreme Court. We're going to talk about the case that comes out of Washington, once again, the Gators Guns case. But again, I acknowledge that Duncan v. Bonta should be in pole position. But shockingly, there's some delays going on in that case. Okay, now, what we're going to talk about today is yet another amicus brief, and this one is drafted by 27, that's right, 27 attorneys general. So today, let's break it all down and let's talk about when a majority of states call BS on your gun laws. Okay, hey, before we get going too far down the road we're going down, I want you to know that all the research for this video was done where? That's right, at GroundNews. Why is that? Well, because I don't like all the bias. I don't like all the headline manipulation. I don't like the big spin machine that is mainstream media. So when you got a news source that's going to scour over 50,000 independent news sources and then give it to you with a biased distribution breakdown, you can actually attach the weight to it that you want. And right now, if you go to ground.news/Washington, or you just scan this QR code right here, you're going to get 40% off a Vantage Plan, which is going to give you every single feature that Ground News has to offer. So if you're finally ready for mainstream media to start treating you like a big boy or big girl, visit my friends today at ground.news/Washington. Okay, America, we are talking about magazine bans. A lot of cases are sitting on the front steps now of the United States Supreme Court, just begging to be accepted. There is one assault weapon ban case right now currently up there. There are two magazine cases. The one we're going to talk about today is the one that's getting all the activity. That is Gators Custom Guns versus State of Washington. We have covered this case extensively because it did happen in our own backyard. But what we're going to talk about today is the fact that 27 attorneys general have authored an amicus brief in support of lawful and responsible gun-owning Washington residents. Okay, now those leading the charge who are going to get the big kudos today include Raul R. Labrador, who is Idaho Attorney General, and of course Austin Knudsen, Montana Attorney General, who we have talked about numerous times before. So in addition to Idaho and Montana jumping in on this, the following states have also signed off on this amicus brief: Alabama, Alaska, Arkansas, Florida, Georgia, Iowa, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, and Wyoming. Now, are we going to sit here and geek out on the law like we normally do? You know, talk about in common use, talk about dangerous and unusual? No, we've geeked out on that enough. We all know the law. We just need to get some of these lower courts to understand it the same way. What we are going to talk about, though, is the other subject we talk about here frequently at Washington Gun Law, which is the absolute Second Amendment mutiny that's been going on at the lower court level, because these attorneys general here have brought this straight to the forefront of their arguments in the amicus brief. They describe this crisis in the following fashion. More fundamentally, it is time for this court to address the repeated defiance of this court's holdings, particularly in jurisdictions that have repeatedly infringed on citizens' Second Amendment rights. The evident errors below and in similar cases manifest a deep hostility to both the Second Amendment itself and this court's precedents. Only this court's review can correct these persistent misapplications, which deprive citizens of their fundamental rights, their property, and their ability to defend themselves. The court should grant certiorari and reverse. Now, although this is incredibly obvious if you watch this channel or any other channel that's kind of covering the same stuff, but to state the obvious, the amicus party here points out, courts and jurisdictions that tend to restrict Second Amendment rights are defying this court's precedents. That is, in fact, the understatement of the year. That is exactly what they're doing. That is how they do it. The attorneys general point out to the United States Supreme Court, the Washington Supreme Court's dismissive view of the Second Amendment is no anomaly. It is emblematic of a larger trend. Lower courts in jurisdictions that most often restrict Second Amendment rights appear bent on distorting this court's Second Amendment precedents. And as the amicus party points out, they got all sorts of new methods for doing it. Whether the mechanism, sometimes distorting the terms arms, other times a convoluted understanding of the common use test, still other times faulty historical analogies, The effect of these lower court decisions is clear: to trammel the constitutional liberties of citizens, especially in jurisdictions already hostile to Second Amendment rights. And you will actually see in this distortion of the rule of law, which we're seeing in these lower courts, where they will actually uphold these bans and then cite to Bruin and Heller and opinions such as that and say, well, it's pretty clear from these opinions we get to do this. Now, is that stupidity or is outright defiance? Well, this is how the Amicus Party puts it. Judicial defiance, not a careful application of the Bruin framework, seems to have driven these outcomes. One specific form of judicial defiance stands out in the case below: a convoluted understanding of the common use test. Because nothing has been more distorted, nothing has been more bastardized by these courts that are hell-bent on civilian disarmament than the complete destruction of what is a very simple test known as in common use. It is a very important test, and it is a major shortcut for courts, because when it comes to banning outright platforms of firearms, magazines, and such, the historical analysis has already been done. So the rule is that if these items are in common use for any lawful purpose, self-defense only being one of them, they may not be banned. And we don't have to go back and do a new historical analysis of what happened, because it's already been done for us. So any court that wastes time doing a historical analysis trying to determine the constitutionality of a ban, they are completely wasting their time. It has been done already. And the only historical analogs that we have that justify a ban of any type of platform of firearm is those which are deemed dangerous and unusual. As the Amicus Party puts it, the common use test, in turn, is the test for discerning whether an arm may be regulated according to the tradition of prohibiting the carrying of dangerous and unusual weapons. An arm is not dangerous and unusual if it is typically possessed by law-abiding citizens for lawful purposes. Put another way, if an arm is in common use today by American society for a lawful purpose, then it cannot be banned. That's how easy the test is. It really, truly is that simple. But you have seen court after court after court openly defy this test. You have seen courts literally say, well, that's just a simple numerical exercise. Yeah, that's exactly what it's meant to be. But they won't accept it, because why? If they accept it, they're not going to be able to uphold the bans. Consider this. The Fourth Circuit, which actually termed the phrase a trivial counting exercise, has found that the AR-15, or the semi-automatic rifle, the most popular long gun in America, is not even covered by the Second Amendment. Oh, and the Seventh Circuit has made that exact same ruling. How are they getting it wrong? Well, they're getting it wrong on purpose, as the Amicus Party points out. These consistent misapplications of the common use test, especially in jurisdictions most likely to restrict Second Amendment rights, require this court's attention. So exactly how are they doing this? Is it through just blatant intellectual dishonesty? Yes, in part. But technically, if you really want to get down into the nuts and bolts of what these lower courts are doing to bastardize the common use test and to uphold these otherwise unconstitutional bans, Amicus Party calls it out for exactly what they're doing here. Instead, too many lower courts use cherry-picked language that is mis- and over-applied from the court's prior precedents to uphold any firearms regulation that comes back before them. And that's how you literally see rulings like, oh yeah, the ban of all firearms is perfectly acceptable under the holdings of Heller and Bruin. And you're like, what case did you read? Now, we routinely hear, especially from those on the other side of the aisle and mainstream media, that we are in the middle of a constitutional crisis. We are in the middle of a constitutional crisis, which is that there is an absolute Second Amendment mutiny going on at the lower courts. And it's not only a mutiny of the Second Amendment, it is a mutiny of the Supreme Court's authority and precedent. This combination of legislative and judicial defiance of this court's precedents is a compounded blow to the constitutional rights of law-abiding Americans. It is again time for the court to step in. So ultimately, when 27 attorneys generals believe that the state of Washington passed an unconstitutional law and the state of Washington Supreme Court got it all wrong, well, they conclude their argument as follows. Washington's failure to come up with any remotely analogous regulation to its magazine ban underscores the importance of a proper interpretation of the Second Amendment at Bruin's Step 1. Otherwise, laws regulating conduct covered by the Second Amendment's plain text, with no basis in this nation's historical tradition of firearm regulation, are allowed to stand without meaningful constitutional scrutiny. Okay, kudos again to Attorneys General Labrador and Knudsen and to all the Attorneys General who were kind enough to sign on to this Amicus Brief. We're going to link it up down below so that you guys can geek out on it for yourself. Don't have to take our word for it. Okay, the case once again is Gators Custom Guns versus State of Washington. We're going to link up everything you need to know about that down below as well. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.